Hello again. This particular module, I wanted to talk about the various components that I would consider to be best practices for workplace investigations. Whether you endeavor to pursue a career in human resources or wind up in any particular managerial position, you'll invariably run across the need to be engaged in or conduct an investigation of something that has happened in the workplace, either by an employee or between employees. In the litigious society that we exist today, and particularly with the emphasis from a labor relations standpoint of view, where many provisions of collective bargaining agreements call for discipline or disciplinary actions be based on just cause. Why do investigations matter? Obviously, employers do have an obligation to investigate complaints, particularly under the various discrimination statutes, whether it be Title VII, ADA, ADEA, with proper investigatory practices, good corrective actions can also provide a good defense liability that may become important down the road. As a practical matter, also investigations provide an opportunity to possibly remedy problems. Once information is unearthed that may become material in one way or another with respect to maybe discipline that could otherwise be averted or remanded or corrected. Sometimes, basically, it's interesting what you find out when you conduct a good investigation. Poor investigations will typically result in, if you particularly wind up going to court, damages, back pay, emotional distress, punitive damages, and attorney's fees. And why this becomes particularly relevant to human resource practitioners is that with punitives, a lot of times the company's insurance policies don't cover punitives for somebody who is really acted way above and beyond the scope of their duties and responsibilities and behaved in a very outrageous and over-the-top manner. Also, complaints come in various shapes and sizes, but do fall to the standard of should have known, could have known, or did know. And just because a complaint is not submitted in writing, it does not mean that it should not be investigated. And also, anonymous complaints should likewise be equally rigorously investigated. Outside of statutory violations, you can have various complaints that occur as a result of threats, hostile work environments, vandalism, violations of policies and procedures, sexual improprieties, theft, drugs, and alcohol. But there are some fundamental steps, if you will, when you go to conduct an investigation that should be considered. One is what happens during the pre-investigation stage, what happens during the investigation stage, what happens when it comes time to make a determination, and then what to do with post-investigation types of issues. Also, you'll need to appreciate the fact that there is such a thing as called attorney-client privilege, and particularly when you're working on behalf of an employer and with legal counsel, whether it's inside or outside, that you carefully ensure that the information that you're dealing with between yourself and the attorney is strictly between yourself and that attorney, in order to keep that protected under attorney-client privilege and not to share it with third parties, which can become then discoverable. So back to the pre-investigation stage. And it's always important to make sure that whenever you're conducting an investigation that you've got good legal collaboration as well, and take advantage of that attorney-client privilege. Also, it's important during that pre-investigation stage to identify potential witnesses and determine if there are any other documented reports of related activity. And then oftentimes it becomes important maybe to consider putting one or more employees on administrative leave. Sometimes that may be with pay or without pay. Typically it's with pay. so that you can, while you're conducting your investigation, preserve the objectivity of that investigation and not have any innuendos of evidence tampering if a particular employee, whether it's the complainant or defendants, that might complain that the presence of somebody else contaminated that investigation. It's also important that a confidential investigation file be created, and that also certainly you want to, in all cases, review that employee's personnel file for possible motivations. Computers, PCs, email, telephone systems, all can be a wealth of information and an important source in revealings when you're conducting an investigation. But remember that promptness is always very critical when conducting an investigation. The more time that goes by, the more that memories begin to lapse and information becomes lost, and it becomes quite difficult to continue on with that investigation. So remember, be prompt, thorough, confidential, fair, document, and then follow through when it comes time to conducting that investigation. Make sure that you maintain the objectivity of that investigation, that you have documented factual support to support your findings, and towards the determination of whether or not policies or statutes were violated, and whether or not misconduct occur, and to end further wrongful actions. Typically, it's important that there be one investigator, sometimes two, but typically I recommend one, depending on the size of the case, just so that whoever is investigating the matters at hand can give it, it brings context to the particular subject matter that's being investigated when one person has the whole perspective from start to finish. Again, promptness is important, so interviews should equally be scheduled as quickly as possible. And note-taking is so important, and keep in mind too that those notes can become evidence and can be requested for production, even in addition to any reports that might be indicated after the investigation. It's important, obviously, to interview the complaining party. Retaliation, it goes without saying, is typically prohibited if it is for the purpose of retaliating against the person strictly because they filed a complaint. And it's always important to remember that you can't always promise complete confidentiality, because sometimes you don't know what you're going to hear from an individual when they say, hey, please, look, I want to keep this confidential, whatever I tell you. Oftentimes it's important to say right back, well, it depends on what you're going to tell me. I may have a fiduciary responsibility where I may have to take that beyond this office here itself. So witnesses become important. Get the witness's name. Repeat the stories to the complainant for accuracy. Consider preparing statements, document the facts, and complainant expectations. I think it's important to follow up with the complainant along the way of investigation and the various steps of an investigation against a complaint, just to let that complainant know how things are progressing and that you haven't really forgotten about them. When it comes time to interview the subject of the complaint, it's going to be important to explain what the particular misconduct is that's suspected or alleged, what the policy violation might be, and your purpose of being there in that investigatory interview is to obtain information, and in a very impartial manner. You're giving the defendant or the target for the misconduct the opportunity to tell their side of the story and ask for witnesses from their standpoint of view. And again, it's important not to retaliate against any of the individuals, whether it's a complainant, defendant, or any of the witnesses along the way in the process. Typically, the way it goes is along the lines of asking questions about who, what, where, when. Try to stay the course with respect to the mainstream issues and not be distracted by other possible, unrelated, interesting types of threads that may appear or occur during that conversation. But emphasize that the retaliation against the complainant and others is prohibited, and then thank, of course, all of the witnesses and everybody involved for their cooperation. But make sure you document, document, and document. When conducting the investigation, analyze the results of the investigation. So look at the credibility of the witnesses, their demeanor, the consistency, the chronology, corroboration, plausibility, history, motivation. One of the interesting things that I find when conducting an investigation is sometimes when the same witness will be spoken to a couple of times and come up with different stories or accountings of what happened over the same situation. And sometimes that, would make me question, the credibility of that particular witness's statements. And then in concluding the investigation, make sure that you gather all the relevant information and documents and determine what policies were violated. And then prepare a full report and inform the complainant and the subject of the complaint of the outcome and the determination. If reasonable evidence exists that a violation occurred, then you have to assess the severity and then determine what kind of discipline or punishment would fit the crime. Make sure that that discipline is not out of line with provisions in the labor agreement in terms of progressive discipline and policy handbooks, and then obviously document the disciplinary action, and then obviously that needs to be placed in the personnel file. If reasonable evidence exists that no policy violation occurred, inform the complainant of such and reiterate the company policy, and then emphasize that retaliation is prohibited. And if the investigation results are unclear, follow the steps for unsubstantiated complaints or suspicion. Maybe a second level investigation, maybe law enforcement involvement or private investigator is appropriate, but continue to monitor what goes on in the workplace. And an important reminder, document the results of the investigation, ensure that the files are current with results from the investigation, and keep investigative files separate, and follow your company's record retention policies. Weingarten is an important right to be reminded of, where particularly members of unions, if they call to have union representation, if they are the target of discipline, they do have a right for a calling of a union representative to be present during their investigation, but not when it comes time to implement the discipline. That would be prescribed in the collective bargaining agreement. Outside customers may become involved as well as internal employees, depending on vendor, employee-employer relationships and interactions that occur. Beware of claims by the subject of the complaint and emails between investigators and others, and always be mindful of HIPAA and ADA disclosures as well. In the arena of employee crimes, make sure you contact the legal department and develop an investigation strategy first and consistent with your various workplace policies. With respect to workplace violence and OSHA, hopefully there is a policy statement which speaks to that within your organization. If not, one should be scripted. Hazard assessment should be conducted, employee training and procedures developed, and also an emergency response team should be in place. Again, with respect to crimes, investigation should be confidential, prompt. Again, administrative leave options, safety of all employees, documentation, and no retaliation against the complainant. And then basically making sure that law enforcement is notified and that attempt to minimize the disruption in the workplace. So, in wrapping up, recommendation, conduct investigations with the legal department guidance, be careful about documentation and correspondence, and give the subject of the complaint every opportunity to be heard. Interview former employees if available, remind all that retaliation will not be tolerated, and share the results and a resolution of the investigation with the complaining party and the subject of the complaint. Avoid dismissiveness, be thorough, use neutral language, and basically maintain confidentiality around the information that you gained, and only share with others on a need-to-know basis, and make sure that you share store the investigatory notes separate from the personnel files, and then avoid instructing witnesses not to talk to the complainant. So, most important, keep an open mind when you're investigating matters, and as you're going through the investigatory process, and don't assume people are guilty until proven innocent. And I think all of this information will help you go a long way in conducting a rightful investigation. Thank you.